Okay. Good Saturday morning. What's up, Andrew?
Good morning, Richard. Good morning.
All right, let's have a go at this one. This is a topic that you kind of tripped across. What's this letter dated? February 23rd. This is recent. This is in the last couple of weeks. So you tripped across this in the office, and today we're talking about it. I mean, there's always some new tactics that collection agencies and bill collectors end up using to try to motivate you to pay as much as possible as quickly as possible. They've used different strategies over the years. I mean, I remember back in the day when I was in the industry, they used to use something called a draft statement of claim, which is basically a completely filled out statement of claim, but not registered with the court system to have a court date set. So it flew in under the radar, as the guise of saying, hey, this is what we're going to do if you don't pay your bill. Here's a copy of the claim, and this is what we're claiming against you. But the reality of it was it held no water. It was really just an empty threat. That eventually, through the number of complaints that came through, got removed from the toolbox that collection agencies could use. But they've got something new here, Andrew. So what's going on here with this letter? Why don't I throw it up on the screen? You can walk people through it so they understand why this is total bogus.
Okay, I'll wait for you to get it up on the screen there.
Can you see it there?
Yeah. All right. So that's a good view of it right there. Yeah. So essentially, this letter came in, was received by one of our clients. At the very top left, the address that the collection agency had on file was our office address, and it was attention to our office, so it came directly to us. Essentially, what this is it's a collection agency threatening to petition an individual into bankruptcy. Now, this is very surprising, to be frank, because the goal of collection agencies is to collect money. That's what they're trying to do, is recover the money that is outstanding and owed to them on a product. And petitioning someone into bankruptcy, generally speaking, now obviously there's going to be exceptions to the rule, but generally speaking, you're not going to get anything out of it, or very little out of it. So petitioning someone into bankruptcy makes no sense. So as you can see here, the letter is indicating in the first paragraph that the account's been assigned to this company, this firm, with the intention of filing an application for bankruptcy order pursuant to Section 43(1) of the Bankruptcy and Insolvency Act, which is known as the BIA. So what I've done is, obviously, I've done a little bit of preparation. I went to Section 43(1) of the BIA to see what that says, and I've got it printed here in front of me. Essentially, there's two conditions that exist in order for someone to make an order or an application for a bankruptcy order. The first thing that must exist is the claim against the individual has to be over $1,000. You can't be trying to petition someone into bankruptcy if they owe you less than $1,000. So that's your first condition. The second condition says that you must have committed an act of bankruptcy over the last 6 months. And then I've printed
What does that
what
even
the
mean?
acts. Well, that's the next thing I was going to get into. So the next thing I got into is what exactly is an act of bankruptcy.
Mm-hmm.
So I went to Section 42(1) of the Bankruptcy and Insolvency Act, which is federally regulated across the whole of Canada. And there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There are 10 potential conditions that would apply and note you as an active bankrupt if you follow one of those 10 items. I'm not going to list them off because there's a few of them, but a lot of them have really no relevance into the normality of life. There were a few others that were, and I'll just read you one or two of them. It's essentially if you remove assets out of your name and assign them to another party to protect your assets, that would be known as an act of bankruptcy.
That's also known as fraudulent conveyance, too, right?
It is, yeah. It's fraudulent conveyance under the case law in the court system, but it's also, and this is the most common one. If you
It's difficult to argue, too. I don't think that's that's something they've got a leg to stand on because there's many other reasons that would trump that to begin with. But anyway, carry on.
And that's my position as well. Now, the most common that I've got on this list here is if you cease to meet your liabilities as they become due. So that essentially is most people that are no longer paying their debt. So if you're unable to pay your credit cards, if you're unable to pay your line of credit, whatever it might be, as soon as you seize those payments, that is now an act of bankruptcy. Now, it doesn't mean you're bankrupt, but it's an act of bankruptcy. So it allows you to file bankruptcy under the Bankruptcy Insolvency Act. But so this threat here from this collection agency is, in my point of view, it's a false threat, because no agency really, realistically speaking, wants to go through the channels of commencing a claim in the bankruptcy court, which costs time and money, to petition someone to go through bankruptcy to determine if the trustee has the ability to take any of the assets, to liquidate, to pay off the debt. Now, most people who owe money, who are in collections, generally don't have property. And when I'm talking property, I'm talking about real estate properties. So houses, condos, townhouses, stuff like that. So the purpose of this letter is just to bait the individual who's receiving the letter to contact the collection agent to say, hold on a second, no, I don't want you to do that. I don't want you to petition the court or have me file bankruptcy. That's not what I want. I can make arrangements to pay you. So I'm trying to look at this balance here. The balance on the letter is $11,700. And on the letter, they are already offering a settlement in order to avoid the bankruptcy application process of $93.76.
And the balance is $11,720, eh?
Yeah, so it's looking around an 80-odd% standard settlement is what they're offering. I actually think it's 83%.
It's 80%.
80%. So they're offering you a standard 80% to avoid the bankruptcy process. And obviously, if the individual doesn't have 9,300, which is more likely the case, because if they didn't have 11,000, they obviously defaulted. They're not going to be sitting around with $9,000 in their bank account. But anyway, the alternative is that the agency would likely say, okay, well, to avoid this process, we need to engage you into a monthly payment plan, which would be somewhere in the range of $200 to $500 per month until the account is paid in full. So that's how they bait you. Is they send you this new tactic letter to say, if you don't pay us, we're going to consider petitioning the bankruptcy court to have an application made to make you noted as bankrupt, so the trustee can assume all your assets and potentially give us our money. So it's a new tactic. It's the first time I've seen this, and obviously I've been doing this for a long time, as you know, Richard. So it's the first time I've seen this type of demand and threat. I believe that the demand and the threat is I wouldn't call it bogus, but it's going to be few and far between. It really makes no sense for them to commence a process in the bankruptcy court, which is going to, like I said earlier, cost them time, and it's going to cost them money to potentially see what might happen down the road in the bankruptcy process.
Do you know what the total cost is for them to petition somebody into bankruptcy or to file an application?
I don't know, to be honest with you. I don't know, but it's a bankruptcy court system. I'm assuming you need to have some sort of agent appointed on your behalf as a corporation, because that's the way it works in superior court. If you're being litigated in superior court, you cannot represent yourself. If you're a corporation, you must have counsel. So I'm assuming you need to retain a lawyer in order to go through the bankruptcy court process, and lawyers are not cheap. So it's going to cost anywhere between $1,000 to $5,000, I would assume, in that process. And
this is going to cost more than small claims court.
Oh yeah, for sure.
Because I mean, a small claims court, it's under, what is it, 20 or 25,000?
It's 35,000 now.
35. Okay, so anything under 35,000, you can basically walk through small claims court. Do you need a paralegal at the minimum, or can you do it yourself?
You can do it yourself if you have someone. If you are if the company that's litigating is the company that owns the debt, then you don't need any licensee. That is a paralegal or a lawyer or a student at law.
It's actually cheaper for them to sue you than it is to try to push you through bankruptcy. And what they'd get out of bankruptcy is probably going to be nothing versus what they'd get by securing a judgment against you. Are they still good for 7 years, renewable 3 times up to 21 years?
Judgments are good permanently. They never expire.
Oh, okay.
You do need to renew your judgment if you have a writ, and then the writ goes against the property, and the writ is renewable every 6 years. Okay. So if if they sue you at the age of 30, that judgment will remain pending until such time as you clear it off. So it doesn't disappear.
So let's sum it up this way. Let me just pull it out of the screen here, because we don't need that up anymore. I think we've already seen it. So I've been in the collection industry since 2000. When did I get it? No, it wasn't even 2000. It was 2003 that I left. I got into like 1992 when I came back from England, 92, 93. Anyway, here's my summary of this from my own perspective. The whole point of assigning debt to a collection agency or selling it to a collection agency, which they usually do for cents on the dollar, we're talking less than 5 cents for sure, often 1 or 2 or 3 cents. It all depends on what the agreement is, but we'll set that aside. But whenever a debt goes to a collection agency, the collection agency's job is to recover the money because they don't get paid up front. They either buy a debt for pennies on the dollar, or they get paid contingency, which is a commission rate based on what they collect. So how do they stay in business? They collect debt and they earn money that way. If they're not collecting the debt, then they don't earn money. They don't have much motive to petition somebody into bankruptcy, because what creditors usually get as a result of a bankruptcy is next to nothing. It really depends on what your assets are, your liabilities, and what sort of situation that you're in. But you can't really cookie cut it from one perspective. But what I'll say from an overview, like if you fly a jumbo jet up to 30,000 feet of altitude and you look down at the earth, from altitude, when you look at this, it seems like more of a threat than anything else. It doesn't hold much water. I suspect that what's going to happen to these types of letters will be the same thing that happened to the draft statement of claims that they used to use back in the day, where they'll probably get, well, when I say they, where the governing bodies that run collection agencies in Ontario, what is that called again?
It's the Ministry of Consumer Services.
Okay, so, and they've got a Collection Agencies Act, and what they'll get is they'll probably get so many complaints on these sorts of letters from the threats and how they feel, because everybody today is basing their happiness and their luck and their emotions based on how they feel, right? So people get outraged over the smallest things today. If these collection agencies think that this is not going to outrage people, they're behaving in a short-sighted fashion. It's going to work for a while, but there will be so many complaints at some point that they're not going to be able to use this threat anymore, because I don't believe that they follow through on very many, if at all. I mean, to me, when you look at the numbers as somebody that's been in the industry, it's money better spent to either put it on collection letter sequences on a dialer, or even to sue it, which doesn't make much sense, to begin with. The other thing to remember is that when the stuff goes to a collection agency, creditors are measuring the performance of the agency based on other agencies. So if they have a portfolio of, let's say, credit cards that goes to 5 different agencies, what they're doing is they're tracking the recovery rate. They're usually quarterly, and they'll track the recovery rate on the 5 different agencies. And the agency that's doing the best recovery rate will get more business next quarter, right? So they're having them fight to compete. So you can see how that forces collection agencies to use every strategy they can possibly pull out of, even from gray areas, which is usually the most profitable ones for them. And to me, this looks like more of a gray area one, to basically improve their opportunities to get more money. Now, I was talking to Andrew before this, but one of the things that they might be doing is, if somebody files for bankruptcy, and let's say they have a $10,000 balance that gets assigned to the agency, if they file for a bankruptcy, then that $10,000 might be removed from the total amount of the portfolio that's been assigned for liquidation, which would mean that would have a small incremental improvement in their liquidation curve compared to other agencies. A lot of this might sound like Greek to you, but just understand that they're not there to help you. They're not there to save you any kind of money. What they're there to do is profit. They have a fiduciary duty to profit to the shareholders of the company, which are going to be the owners. This is an interesting strategy. I have a feeling it'll probably work on some people. But hey, guys, now you've heard the cold hard truth on some of these things that happen behind the scenes and why they happen. Is this underhanded? I don't know. You guys can decide. It's probably more of a gray area thing. What do you think about this, Andrew?
Well, I believe it's going to be deemed a violation of the applicable laws under the Collection of Debt Settlement Services Act.
You're a licensed legal professional.
Yeah, so there are provisions in the act that covers collection agencies that requires them not to use undue pressure and offensive language and certain other things. And to me, while this is not something that is impossible, it's not like they don't have the option to move forward with this, but I believe this is being used as a tactic, as undue pressure on the individual. And as you said earlier, Richard, I think as more and more complaints start to build on this type of behavior, and the ministry receives the complaints from the consumer, I believe they're going to start asking the agencies to rescind this type of letter from their letter sequence, meaning that they can no longer send it out to the consumer as a threat. They're likely going to ask the agencies, how frequently are you moving forward with such tactics? They're going to be told very little, if any. And then the ministry is going to say the same thing they did with the draft statement of claims about 15 years ago. They're going to letter all the agencies and say, stop using this tactic. It's deemed unlawful under the act.
Finding and introducing consequences to the agencies that did not follow the rules properly at some point, and they all had to comply eventually.
Yeah. So that's my interpretation of it. I think it is undue pressure, undue force. And I think the ministry will incorporate the restriction of this letter at some point in the future. But this is the first time we've seen it. It only was dated roughly, 20 days ago.
2 weeks ago, yeah.
Yeah. So it's a new sequence. It's a new attempt by the agencies to see if they can gauge a response from the cardholder.
I'll give these guys a slow clap for being creative. I mean, obviously they had shown this to their legal team and took not a conventional, but more of a conservative approach to stuff like this, which would be the smart business decision. So we'll see how it unfolds. But I think I'm with you on this. I don't think that this is going to unfold in a bankruptcy very often. We'll see how it goes, but it appears to be more of a threat to motivate a settlement at 80 cents on the dollar, which is kind of conventional. I mean, it's not much of a savings, but it does get them the money back if the scare tactic works anyway.
Yeah.
Anything else people should know before we start to wrap this up?
Well, if you are struggling with credit card debt, there's a ticker at the bottom of the screen there that directs you to I think it's our webpage. So I'll let you talk to that, Richard, because there it is, totaldebtfreedom.ca. There's the web domain. Mm-hmm. Click on that, fill out the form for free quotes. We offer a free consultation between 15 and 30 minutes. It's a quick assessment of your situation. And if we can't help you, we direct you to the right path. Obviously, when you fill out the form for the consultation, we also suggest you book a call. If you do not book a call, then we're not going to be able to contact you to discuss your situation. So fill out the consultation form, then schedule a call with a representative. We can spend the 15 to 30 minutes to get you a consultation. It's free of charge. We can see how we can help you. If we can't help you, we will direct you into the appropriate path.
There's really just 3 qualifiers if you need help. 1, you've got to over 15 grand worth of debt. 2, it's got to be Canadian debt. So even if you live somewhere else in the world, you're now an expat and you want to deal with it, we can still help you out. And 4, you've got to be struggling financially. So if you've been throwing money at the problem and you've seen it not move much over the last 6-12 months and you're not putting any kind of dent in it and it looks like you're going to be in debt for decades, this is your opportunity to do something about it. So hit up totaldebtfreedom.ca. Like Andrew said, fill out the form, book a call, get a quote. There's stuff like this that we've been on top of for decades now. It's one of the most effective programs. It is not cookie cutter, one size fits all for everybody. Some people pay very little, some people pay a little bit more, but everybody that gets out of debt with our program graduates with a better credit score on the day that they start, and they save a ton of money based on what they owe on the day they start. Could be 50%, could be 70%, could be 25 or 30%, but you save a ton of money. So get a quote based on your type of problem, and we'll get you started. Do we have a show topic for next Saturday, Andrew?
Not as of yet, no.
All right. If you guys want to provide a suggestion, the comment sections are open in the videos. So if you have something you want us to cover, let us know. We'll see you guys in the next video. Have an amazing weekend.
Enjoy the week.